Hi, good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference. Today is March 9th, 2023. I will first go over the questions that I have marked as frequently asked questions. There's actually only one frequently asked question that I saw today. After that, I will go over the questions that have been posted, and if time permits, I'll take new questions. With that, let's get started. The first frequently asked question, actually the only one, is volunteering on a non-profit board committee while on an H1B or H4 visa. So the question relates to something that people ask quite frequently. Can I volunteer while on a limited intent visa like H1, H4, F1, F2, L1, L2, any visa that has a limited intent? Can I volunteer? And the answer is yes, but there are a couple of considerations. First of all, from your perspective as an individual, you must make sure that you are not getting paid in cash, in kind, or in benefits. So for instance, if somebody has promised you, if you serve on our nonprofit board, we will give you free tickets to XYZ events on an ongoing basis, that could be compensation. So you want to stay away from compensation in cash or in kind. How about reimbursement of out-of-pocket expenses? What if you spent $1,000 traveling for some purpose related with the nonprofit? Could you be reimbursed those? I think that should be acceptable. Reimbursement is okay because that's not benefits or that's not compensation. Basically, you are getting reimbursed for money that you have spent. So that's the individual's perspective. The summary is you can do it as long as you don't get paid in cash, in kind, or any benefits. How about the employer's perspective? Now here the question relates to a nonprofit. It's relatively easy. But could you volunteer for a for-profit organization? Could you work for an Oracle or an IBM without getting paid? That gets more complicated. Under the Fair Labor Standards Act, by the way, I forgot to check something. Let me make sure you guys can hear me okay.
The conference is now in conversation mode.
Hey, could you folks confirm if you can hear me all right? Can you hear me okay? Guys?
Yes, sir.
Okay.
Yeah, I can hear you.
All right. Thank you. Okay. So
The conference is now in presentation mode.
going back to my original question, so what if it's a for-profit corporation? That's more complicated because under Fair Labor Standards Act, as far as I understand it, there are some limited purposes for which for-profit corporations can let people work without getting paid. And those purposes are typically sort of an internship, which is for the benefit and the training of the individual rather than for the benefit of the corporation. There is more to it, but that's something that's not really your problem, that's the company's problem. So to summarize all of this, you can work if the company is non-profit, there is no issue as long as you don't get paid in any way. If it's a for-profit, the company could have a problem unless they tailor-make the program according to the principles of labor laws. Okay. Any follow-up questions on this issue? *5, please. Yeah, I also want to confirm that for such a person who's just volunteering, there should be no issue for visa stamping or for green card process. Now, this was the only frequently asked question. I am now going to go back to our list of questions and start from the top down. So the first question is, filing I-485 and I-130 for spouse while I-485 is pending. So the timeline is, I came on an F1 visa, I filed I-526. That's the investment-based green card. 526 got approved. In August of 2022, filed for my I-485 and work authorization, advanced parole. October 2022 started change of status from F1 to H1B. Then in November, I-765 was approved, which is EAD. December 2022, I traveled overseas, got married, obtained H1B visa stamp, returned to the US, wife obtained H4 visa stamp. So she's here on H4, he's here on H1B. He has got an he's got a 485 pending. So question, if my wife arrives in the US and a visa is available, can I file a 485 for her? Yes, absolutely. Do I need for my 485 to be approved? No, not at all. And by the way, this is true for all 485s, not just based upon the investment-based category, EB1, EB2, EB3, any category where you have a 485 pending and your spouse comes in on an appropriate visa like an H4 or an L2, you can apply for her 485 as long as the dates are current. And the law only says she's entitled to a derivative green card if you are married before your green card is approved. So you don't have to be married when you start your green card. Okay, that's one thing. When my I-485 was filed, the final action date was current. However, it is now June 2018. Will this affect the adjudication of my pending I-485? And the answer is yes. They will not adjudicate your case until the dates become current. The only exception is sometimes they are at the tail end of their adjudication. In those cases, they might get a visa, and sometimes you get approved even though the dates slide back. It's because they've completed their adjudication and they have sought an immigrant visa from the State Department before the dates slid back again. Those are the rare cases in which you will see approvals even while the dates are sliding back. How do you know if you are in that category? You really cannot. You can try calling the USCIS customer service. In my experience, they don't have that information. Okay. Star 5, if you have a follow-up question on this, press star 5. I also want to add, once you get your green card approved, and your wife's 485 is not filed or is still pending, you have to figure out how to keep her here because she will not be able to maintain her H4. But you can, of course, if you have, you can file an I-130 for her separately, but she would have to be outside USA or have another visa status because H4 is no longer available if your H1B goes away because of the green card approval. I have a follow-up question on this from Atlanta, Georgia. Georgia, go ahead, please. I can hear you.
Yes, sir. Thank you. So we have a question. My son applied for me as a U.S. citizen for 130, and it got denied because they suspected fraud, marriage fraud.
This is not the time for new questions. I'm only answering questions that follow from what I have discussed. So please stand by. If I have time, we'll get to that, and I think we'll have time today. We don't have too many questions. We have 11, 12 questions. I should be able to do them in half an hour, okay? Stand by.
Thank you.
Of course, no problem. Okay, let's go back to our, this is done. Okay, back to the next question. H1B cap exemption and working with multiple employers. I am on a cap exempt H1 with employer A. In 2021, employer B filed my cap subject H1 that got approved. So you have at least one cap subject approval. You didn't join that employer. After that, you found a part-time concurrent H1 job with employer C. Can I use that cap subject H1 and transfer to employer C? And I think you can, because once you have been approved under the quota, whether or not you joined the employer, it shouldn't matter as long as your case was not withdrawn before the start of your H1B, even if you didn't join, you should be able to use that H1B. Okay, I don't think that should be a problem. *5 if you have a follow-up question. Press *5. No new questions, only follow-up questions. So in about 10 minutes, I will close the conference. No, not 10, 20 minutes. I'll close the conference and then we can just make sure that everybody who's here, their questions get answered. Okay, next question is F1 employment with international organization and F1 entry from Canada. While on an F1 employment with an international organization EAD approval, can I concurrently work for another for-profit employer on the same EAD if my combined hours are less than 20 hours per week during school year? That's something you have to discuss with the school, okay? If the school is okay with it, I don't see, as long as you don't violate the school policies and the F1 regs, I don't see why not. On your blog, you mentioned that I-485 pending applicants could work multiple jobs. Does this apply to this case as well? And the answer is, if you were on first year OPT, optional practical training, and you wanted to do 3 jobs or 10 jobs, as long as they are in your own field, you could do them. You could work 80 hours a week. That's fine. STEM jobs are different. You can still do multiple jobs. But you are talking about International Organization EAD approval. I'm not sure what that means. If you are on the phone, press *5. I would like to know more about this. Yeah. So this is area code. This is from Massachusetts, US. Okay, Massachusetts, I can hear you. What do you mean by International Organization EAD approval?
Hey, good afternoon, sir. This is not exactly my question, but I had a similar follow-up on
Oh,
this.
acha, okay. Just one second.
Which
Let me just make sure that they are not on the call. So I'm not sure what International Organization EAD approval means. Basically, if you are talking about pre-completion OPT, there are different rules. OPT, the rules are different. STEM OPT extension rules are different. So it all depends. Curricular practical training, the rules are different. But normally what happens is you have a proscription to a total number of hours in certain EADs and no such proscription, no prohibition in some others. So it depends upon what you have. Since you're not here, we can't really clarify that. So go ahead, Massachusetts, you had a question.
Yes, sir. So as you stated, we can do multiple jobs on an F1 OPT during the first year. But the only caveat is that it should be within our field, correct? And we can exceed over 40 hours. Is my understanding correct?
Your understanding is absolutely correct. Not only that, you could even run your own business. So I'll give you an example. I was contacted by a graphics designer from New York. She had finished her degree in UX UI design, I think, or was it graphics design? It was related. And she wanted to do freelance work because she couldn't get an OPT. So what I had her do was, I said, fine, do this, but keep track of your invoicing. How many hours are you invoicing and for what work? And keep your contracts with the clients, with your clients and customers to show that you were working in your own field. Not only that worked out fine, she actually traveled and returned showing that paperwork at the airport, and the government made no big bones about it. So you can actually be freelancing if you want, first year of OPT, as long as it is in your own field, as many hours as you like, no less than 20 hours each week. Paid or unpaid. It can even be unpaid. Okay? Make sense?
And this is totally legal, right?
Legal, totally legal, absolutely.
Yes, sir, it does.
Absolutely legal.
All right. Thanks.
Yeah,
Thanks so much for taking my call, sir.
One more thing you have to remember, when you are on first year of OPT, let's say you start freelancing, but the moment you hit STEM OPT, you have to be employed, true employer-employee relationship. It cannot be freelancing for yourself. Okay.
All right. And another quick follow-up on this, sir. So, do we have to update our second employer's information on the service portal as well?
Yes.
Like,
No. Hang on.
Would it be the same procedure as the first employer?
In the first year OPT, you should contact the DSO, let them know this is what I am doing. I do not think they have to do much on the portal, but for STEM OPT, they have to. If you are doing multiple employers, they have to give you approval for each one. Okay.
And by they, you mean DSO has to give?
The DSO, yes, not the USCIS. Okay.
Okay.
Good
Perfect.
luck.
All right. I've understood everything, sir.
All
Thank
right.
you.
Good luck, sir.
Thank you. Take care.
Bye-bye. Okay, I'll lock the conference in about 14 minutes just to make sure that we get people who are already here. Let's go on to, so I finished this question. Oh no, wait a minute. There are other parts of this question. Can I enter the US as a Canadian citizen via road, port of entry on an F1? Sure. When an I-140 is pending. Okay, so this can get complicated because if the issue of an I-140 comes up, although there are rulings in the context of TN visa or TN status where they say that if you have an I-140 pending, that is by itself not a ground for denial of entry. But I'm a little nervous when people have an I-140 pending and they travel. So F1 always carries the risk that you could be denied entry because F1 is a single intent visa. Okay. So I would avoid this situation. There are some things in your favor, but ideally be on H1B if you want to travel or have advanced parole when you want to travel. Okay, you're not here, so I can't say *5 if you have a follow-up question. Next question is from, it's the question number 5. Green card options for F1 visa holders with non-working green card parents, and H1B gap and its implications for international students on OPT. No idea what that means. I'm on F1 visa. My parents who are green card holders are living in the US. They want to apply for my green card, but they do not work or earn. What are my options? Well, you can get a co-sponsor if your concern is sponsorship. And a co-sponsor can be anybody who is a green card holder or US citizen, and they don't have to be related to you. Okay. My student visa expires on 16th Feb 2026. My OPT end date is 2026. April, employer files H1B. Will I be able to stay and work? Yes. So if you get gap is good till the date you hear about your H1B rejection, approval, whatever. And on October 1st, the H1B kicks in. So the gap takes you to September 30th. That's typically the way it works. I want to go back to your first question about parents who are green card holders living, they want to apply. Does that interfere with your travel? So that referred to the first question, which was about the question before this one, which was about a Canadian traveling when they have an I-140 pending. So the same problem happens. Technically, they could at the border create a problem for you saying, oh, you have a green card pending, how can you travel on a student status or visa? As a practical matter, they may not. Okay, so I can't really predict. Avoid this situation if you can, where you have an I-140 pending and you're traveling on F1. Okay, *5 if anyone has a follow-up question on these issues. No new questions, any follow-ups? *5. Okay, let's see. This one is area code 949, which is California. California, go ahead, please.
Hi, sir. This is Shreya Gupta. We connected on green card issue previously.
Okay.
So can my mom, she's a green card holder in United States. What are my chances? So she doesn't have her citizenship right now.
Okay.
So can she apply for my sponsorship?
Yes, ma'am, she can, but the problem is, I'm assuming you are over 21 or older, right?
Right, I am, yes.
Okay, good, me too. Excellent.
But I am still unmarried.
Okay. Well, the good thing about that is, if you're unmarried, no matter what age you are, unmarried, never married, divorced, as long as you're single, your green card holding parent can apply for you. The bad news is if you're India born, that category is backed up, family category, I think 2B. That's backed up, what, 6-7 years, something like that. So it'll take a long time for the green card to come. But can they apply for you? Yes, they can, as long as you remain single. Okay?
Okay. Yeah, thank you for answering that. I have a follow-up question, and I believe you might want to take this up towards the end of the call, and that's regarding the
Let's
so,
just take.
around the calculation.
Sure. As long as you stay on the line, I'll close the conference in about 9 minutes, and I'll make sure everybody who's here, their questions are answered. Okay? So just stay on the phone. I'll get
Okay,
back
sir.
to you.
Thank you.
All right. Bye.
Thank you. Okay.
Okay. So then we did the F1 on the non-working green card parents. Okay, we finished that. Next question is from number 6. Timing and restriction of F1 visa issuance for new and continuing students. My daughter is currently on H4. Next year she will age out. Planning to convert her to F1 by traveling to India. I think that DHS is now allowing F1 visa up to 365 days. Yes, they are. But you still cannot enter, 30 days before the school start date? Yeah. So we are planning to appear with F1 stamping June, July based upon availability of visa. Since this is a continuation of her studies, can she enter more than 30 days in advance? I think she can. That would be the most logical conclusion. See, because she's not applying for a new course. She is going in the middle of her course to India to get a visa stamp and come back. I think she should be able to, more than 30 days ahead of time. You found some information, continuing students. I think you have been emailing me as well. This looks familiar. Yeah, so this is from the travel.state.gov website. It says that F visas can be issued up to 365 days ahead of the start date, but you can only enter 30 days ahead. Yeah, that's what I thought. Continuing students may be issued visa at any time as long as they are enrolled in a approved school. They may enter the United States at any time before the classes start. Exactly. So that makes sense, right? That's the logical thing. So yes, I would confirm that makes sense. *5, if you have a follow-up question on this, press *5. Okay. We already finished this one. This was a frequently asked question. CSPA age calculations for certain adjustment of status people. Aging out in June 2023. H4 is June 2023. Without leaving country, apply for change of status from H4 to F1. Go outside, get F1 visa, come back. If I go with change of status, can he stay on receipt within country after 1st June? Yes, absolutely. Can he continue his education? Check with the DSO. To the best of my knowledge, he should be able to continue to go to school. Okay, but please double check with the DSO. This is a little bit of a twist in the law. Should he apply for a B1, B2? I am not sure that's a good decision. I think if he's allowed to go to school, staying is not an issue, but if he's allowed to go to school, that would be, change of status would be a good option. Okay. I'm not sure B1, B2 is the best option for them. Also from the same university, can we get 2 I-20s, one for change of status, another one for F1 visa interview? Check with the school. I don't see why not. Only problem is, if you depart while the change of status is pending, that change of status is abandoned. Then you have to get a visa and come back. The change of status has no meaning at that point of time. Okay. *5, if you have a follow-up question on this, press *5. All right. Let's go on to Oh, there is a follow-up question. This looks like North Carolina. Okay. North Carolina, go ahead. I can hear you.
Hi, Rajiv. This is Tanmay. Yeah, actually, I have the questions on that non-profit org. So is that an issue? Sorry, means I did a lot of Googling but not find any concrete answer. That's why I posted this one.
What is the question?
So
Sorry.
for the non-profit org, all right? Sorry, this is for like voluntary on the non-profit.
I already
board,
covered
right?
that.
Vice president position without.
I already covered that.
Oh, you did?
Yes. So wait for the recording.
Sorry, I joined.
Yeah.
late.
Yeah.
Okay.
I can't go back to it. Already done. All right.
Okay, only one more question. So I'm planning to go to India and filling up my DS 160, right? So is that okay to mention? Like, do I have to mention that I'm working for the non-profit or on volunteer base?
You should always err on the side of too much disclosure. It's okay to tell them you are. This is a non-profit volunteering activity. It depends upon the question on the DS 160. If it asks about work, that's not really work. It's volunteering. You can make a note that I'm not working, but I am volunteering. So I think that should be okay.
Gotcha.
All right. Good luck.
Thank you so much, Rajiv.
You're welcome.
Appreciate it.
Bye.
Thanks.
Let's go on to the next. Okay. Then this is question number 9. Sponsorship by U.S. citizen child for parents' green card household income requirements when the child turns 21. Currently on H1B with priority date Feb 2022, daughter is a US citizen, 14 years old. When she turns 21, can she sponsor? Yes. What are the household income conditions? Well, you have a couple of things you can do. Of course, if you have accumulated Social Security Administration 40 points, as you note, you should be exempt. But you can also get a joint sponsor, anybody who's a green card holder or a US citizen. In addition, your own assets, especially those that are cash or cash equivalents, can be counted. Okay? So all of them are possible. *5, if you have a follow-up question on this, press *5. Should you work on creating some revenue for my daughter? I don't know how you can do that, how that would help, but I think the other two options are good options. This is from Texas. Okay, Texas, no new questions, only follow-ups, please. Do you have a follow-up question on what I discussed?
Sir, this is Raj. I have a heads up actually. So the question number 10 was posted by me, but between the time I posted and now the question was changed. So just a heads up. Maybe I don't know if you still want to provide an answer for next question.
Just wait.
Just
wait until I open the conference for all questions, which I'll do in about half an hour, 20 minutes or so. Okay? So just wait.
Yeah, sounds good.
We'll get to it. I just want to finish the posted questions first. Can you explain USCIS updates to Child Status Protection Act? Okay, so did I already cover this issue? I can't remember. Number 8. Yeah, I think I forgot to cover this part. They wanted a clear explanation of what changes have been made by USCIS in CSPA calculations. Well, the only change is previously CSPA would protect your child as long as they did not turn 21, all other factors considered, all other calculations made. They did not turn 21 before the dates for final action became current. Okay, so it could happen that based upon the filing dates, you have filed the form I-485, but the child loses out because the dates for final action did not become current before they turned 21. USCIS has said, we won't do that. If you have been able to file the 485, the child is protected because we will only look at the dates for filing, not the dates for final action for CSPA calculations. It's as simple as that. There's no other big change in this. Okay. So going back to, we covered this. Yeah, let me close the conference so that nobody else can log in. Security.
The conference is now locked.
Okay, I just locked the conference. Preserving H1B status by switching to H4 EAD. Sure, you can do that. No problem at all. Is there a way I can apply for H4 EAD without stopping work? Yeah, so you can apply with a date in mind, and you can continue working on H1B the moment your H4 is approved. By the way, coming to think of it, why don't you do this? Because USCIS will now premium process H4 and H4 EAD if all of them are included in a package with H1B premium. So anytime your spouse, Raj, your wife, is applying for H4 EAD, oh, Raj was here just a moment ago. That's the question number 10. So anytime your wife is going to apply for H1 amendment or H1 extension or H1 transfer, you can package your H4 and H4 EAD. Within 15, 20, 30 days, you got your approval. Raj, press star 5 so I can unmute you. Press star 5. You had a follow-up question on this. So let's take this question now. Go ahead, Raj. I can hear you.
Yeah, hi Rajiv. So unfortunately, my wife, already, approved. She filed her, H1B extension before she got I-140 approval. So unfortunately, I'm not eligible to, to apply that premium process to apply H4 and H4 EAD.
Look, I would sit down if I were you with their lawyers and figure out, is there anything we can do to file an H1B, whether it's amendment or it is, the salary changes. I can sounds like an excuse, but I can certainly try, do an amendment and file, or if the location changes, do an amendment and file your H4 and H4 EAD at the same time. The other option is to apply for an H4 EAD, but the problem is there is no guarantee about the timing, no matter what you do. Okay. One thing I noticed, which I wasn't aware of, that's something new I learned, that USCIS is actually approving H4s as far ahead as 1 year before the start date of the H4. Okay. So what does that mean? H1 they won't approve more than 6 months ahead of time, but H4s they might approve as much as 1 year ahead of time. So what you could do is, you could ask for H4 change of status 9 or 10 months from today, and chances are by that time you will also get your EAD. So there's some risk there that you may not get your EAD by that time, but I think you will. So that's the only other option you have. Either premium the whole package or ask for a date of H4 EAD about 9 months from now. Okay?
Okay, but Raju, my project got ended end of last month. So right now, considering my market situation, I want to switch to H4. So I don't want to maintain HP because now, and also have a travel plans this June to India. So my question is can I apply now for H4, and once I get the receipt, and I need not to worry about maintaining H1B, right?
Yes, but if you are traveling, Raj, when are you planning to travel? When are you planning to travel?
In the May end. I have a visa appointment on June 9th.
Okay, so
I scheduled for H1B.
Yeah, you'll have to do an H4. I don't know if you can convert that appointment, but no harm in asking them. Okay.
I got to know I can. I booked for H1B visa appointment, but I got to know, I read some forums that I can still attend it and I can get approval for H4 visa.
Look, I would not rely too much upon the forum information. There are a couple of sources that
Okay.
you should go to. Go to the frequently asked questions posted by the State Department and the visa services. And two, I would actually email the relevant authorities just to make sure that you can convert. I know like you can make changes to a pending DS-160, but can you
Yes.
also completely change the
Right.
nature of the appointment? I'm not so sure. Double check it. That's what I would
Mhm.
have you do. Okay. But yeah, certainly you can do that. Get an
Okay.
H4 visa
Okay.
and come back. That would be great. Okay.
Okay, and once I get the receipt, I can, as soon as possible, I can apply for H4, and once I get the receipt, I can stop. Need not to worry about maintaining H1B, right?
No, you do not. Once you get if you file your H4 conversion on a timely basis, which is within 60 days of losing your job, terminating your job, as long as your I-94 was more than 60 days remaining, you can stop worrying about having to maintain status because you have an H4 pending. When you leave the US, that
Okay,
H4
and
that H4 will be dismissed, but that's okay. You can get a visa stamp and come back.
okay, yeah, sounds good. And I also have H1B pending, H1B amendment pending, because at the start of February I changed my client, so I need to withdraw it, right, before immediately, right? Because
You should withdraw it, but get your H4 filed for sure within the 60 days following your termination. Okay.
Okay. And can I also file H4 EAD, or do you recommend
Why not?
to file once I come back to you?
Why not? But the problem is when you leave, you're going to get all these cases thrown out. So why spend more money than you have to?
Okay, so you recommend once after come back into US, then file for EAD, right? So I thought
Yeah.
if I file now, I'll considering the processing time, it will be
No.
good for me. But I don't know if they will deny if I exit the country.
Yep. It's abandoned if you exit the country, so it doesn't make any sense. All right.
Okay, yeah, sounds good. So to summarize, I'll proceed with withdrawing the amendment, H1B amendment, and filing H4 change of status, and then I'll confirm with the authority on that my appointment.
Sure.
And once I return back, then I'll proceed with EAD.
Sounds good. Good luck to you.
Yeah, thanks so much.
You're welcome. All right. Next question is visa stamping. This is number 11. Visa stamping options outside the US for F1 visa with the previous H1B status. After 6 years of H1B, applied for F1, approved. Never left USA. Planning to go for visa stamping. Opinion about my chances. Get my visa stamped at the Mexican or Canadian border. How can you stamp a visa at the border? There's no such. You must be thinking about something else, because you can't stamp your visa except at the consulates. Okay. And what your chances are, that's very difficult for me to predict. That's totally up to the government authorities. I can't really tell you that. Okay. Sorry. *5 if you have a follow-up question on this. *5. Okay. Next question, number 12. Reinstating an expired unused H1B in the cap exempt category. Reinstating. I have an expired utilized H1B stamped more than 10 years. Well, we know for sure that for 6 years you are good. 10 years, I don't know. There's something called a remainder option, but that doesn't apply to somebody who hasn't come to the United States at all. You can try, but I think 10 years may be too long. I think 10 years is too long because the law says 6 years. Now, we have argued and the government has agreed that the 6 years begins from the date your H1B approval ends. So if you were approved from 2017 to 2020, we'll count 6 years from 2020. Okay. But even that may be too much because 10 years is just beyond that also. I doubt you can do this. You can try. *5 if you have a follow-up question. And this is the last posted question that says, I came to USA on an H1B through a consulting company for one of their direct clients. Project went on hold. No payroll. 4 years later, I traveled to India. And next thing is there's a gap of 3 months. Stamping put on hold. Was I out of status? Yes. Will I face any issues with H1B, H4, L1 stamping? Ankit, that depends upon how much of an issue the government wants to make. Okay. Now, if you had talked with me before you left, I could have cautioned you that this was going to be a problem area. And if you had said yes in the DS 160 that you were out of status, they could not have stopped you. They could have delayed you. They could still 221G issuance in your case. But could they have stopped you? The answer is no. However, you said no to the status of being out of status. They can make an issue of it if they want. Although it seems to be a minor issue, but with the consulate, you never know. *5, if you have a follow-up question on this, press *5. Okay, anyone who has any question, press *5. Anyone who has any question, press *5, and I'll take you in the order that you logged into the conference. I have 5 questions, 6 so far. Okay, 6 it is. We'll do all 6. Let's start with California. California area code 510. 510, I can hear you. Go ahead, please.
Yeah. So this is related to the CSP. So my daughter is a special needs child, and she will be aging out in 6 years from now.
Mm-hmm.
And I don't think I'll have the GC by that time. So I'm wondering, is there any other option? What I understand is after 21 years, she cannot be an H4. So if that's the case, is there any option available considering that she's a special needs child?
The only thing you can do is, if you go to our frequently asked questions, we have some information. Oh, there are 7 people with their hands raised. Okay, I'll do the best I can for all of you. I'll finish the questions, of course. Don't worry about that. So the only thing I can think of is that you will apply for her green card as long as she is single. You can apply for her separately after you get your green card. But in the meantime, you can keep extending, convert her to tourist status and keep extending that tourist status as long as her green card is pending. This may or may not work, but you can try. That's the only option I see. Okay?
Okay.
I also want you to do one more thing. This is very unlikely, but it doesn't hurt to check. Sometimes members of Congress can pass special laws for children or for people in special situations. They're called private bills. Private bill. So you could Google immigration private bill and you might see what kind of help can be given to you. There's a procedure for it. Very unlikely, but it's certainly in the books.
Okay.
All right?
Okay, sounds good. Thanks for that information.
You're welcome, sir.
Thank you.
You're welcome. Good luck. Okay, so 6 more people. Let's go to Georgia. 770. Let me see if I can find that in my dashboard. 740. Okay. 770, I can hear you. Go ahead, please.
Yes, sir. My son is a U.S. citizen, so we applied 130 through him, but they denied my case because they suspected marriage fraud.
Marriage fraud. Well, your case was not based upon marriage, right? What kind of marriage fraud?
No, earlier we applied 130 with a marriage. First they approved it, then they denied it because they suspected it wasn't for the right purpose.
Okay, so
what are our options?
What are your options? This is not a case that we can discuss in a community conference because I would have to look at the paperwork. I would have to look at why they denied the case.
Okay.
But because this could end up in litigation, you have two choices. You can either get a local lawyer wherever you are and somebody who does litigations and see what they suggest, or you can consult us. We can refer you to somebody who does litigations all over the country. Frankly, we don't have time to do litigations. We did a lot of them during Trump administration, but right now we are so busy with our transactional work. So why spend money on two lawyers? You might be able to.
Also, I'm also a Canadian citizen.
That doesn't change anything.
If I go back to Canada, can I?
That doesn't change anything. If you have a fraud finding against you, you will have a problem forever. It's a forever problem, not a temporary problem. Okay?
And how does the waiver of fraud work? Is that part of litigation?
No, waiver is a separate issue altogether. But somebody who does deportations, federal litigations, and transactional work, it'll be difficult to find somebody who does all of these, but you never know. It's worth trying. Okay. And waivers are very difficult to obtain. Fraud waivers are very, very difficult. Okay?
So you suggest litigation?
Well, if there is ground for litigation, you can't litigate just because it sounds good. If you have no grounds, then what is the point of spending money on that, right?
That's what I'm asking. Like, what are our options?
And
like, do we go back to Canada?
This is like asking a doctor, will the patient survive? I don't know what the disease is. So what I'm trying to tell you is get a local doctor. You might save some money. But if you want me to review the case, I'll be happy to do so. Okay?
So we'll reach you directly.
You can reach out to me directly. My email is help@immigration.com. All right?
All right.
Good luck, sir.
All right. Thank you.
Take care. Bye-bye.
Bye.
Okay, let's go to the next question, which is Cleveland. Cleveland, where are you? Just a second. Got you. Cleveland, go ahead, please. I can hear you.
Hey, hi. Thanks, Rajiv. So, Rajiv, I'm on a H1B here in the USA, and my around 15 months left on my max out. Okay, so I recently joined a new employer this month only, and motivation that they will file my green card on an immediate basis, and provided they have some approved privileging determinations that they have.
Got it.
So after joining, what I found out is the PWD, the approved PWD that they have is of a DBA role, which is database administrator. And one more thing I found out, like I'm only eligible for the EB3 category. So with that said, my current role and even the prior experience is a ETL developer and ETL technologist. So we definitely share few common technologies between the DBA role and then the ETL developer role. Technologies, not the skill sets and not the exact work. So there are like a 20-30% of a match. That's what I predict, but I don't see like it's a match. So
well, hang on. Hang on. I think it's very difficult to argue that an ETL developer extract, transform, load is the same as a database administrator. I think that's a very difficult thing to argue. Anybody who understands technology would kind of laugh at this case and say, no, I don't think so. Okay. But if the database administrator was doing generic work, they were also helping with some transactions, database transactions, SQL, etc. It might be argued that, yeah, these roles are quite similar. So it depends upon the case, but I think it's difficult. Okay. Whatever you do, don't try to change your background to match this. Don't try to bring in letters that are not true. Just be careful with that. Okay.
Okay, I got it.
Yeah. Anything else?
Okay. And suppose if the I-140 get denied with this all these dilemmas, and if they able to file my form before 365 days of my max out, can I still be able to get another year extension?
Yeah, because if you
on
file an
even though
appeal,
I-140?
if the I-140 gets denied, you file an appeal, you should be able to get one more extension and file another POM application. So
Okay.
you
With
should
the
be
right
able to,
PWD.
yeah, you might be able to save your ability to work on an ongoing H1B by filing an appeal. So that's something your lawyers have to help you with the timing, but that's certainly possible. Okay?
But the earlier case is like a very conflicting. That's what you mean.
Yeah, I don't think that's gonna work.
The DBA, PWD, and the UTL developer.
Yeah, I think those are quite apart, and I would be reluctant to advise a client to use that unless I could prove that you have that experience. Okay?
Okay, got it.
Good luck.
Thanks, Rajiv.
You're welcome. So the next, now we have 4 people left. The next one who logged in was California, area code 949. Let me look for 949. Here we go. 949, I can hear you. Go ahead, please.
Hi, sir. I'm Shreya Gupta. We connected earlier, so my question remains the same. It's around CSPA. I wanted to understand, like, I do not have the concrete dates as to when was when was my file approved. So I sent you the email that had the dates, and there was a rough calculation that says it's 4 years and 1 month. And I just wanted to understand, is there a better way I can calculate the CSPA and then reach out to the legal
Yeah. Actually, if you just Google USCIS Policy Manual CSPA, USCIS Policy Manual CSPA. I'm doing it myself right now as we are talking. USCIS Policy Manual CSPA. Yes, it brings you to chapter 7, child stat, volume 7, chapter 7, yes, volume 7, chapter 7 of the USCIS policy manual. It tells you exactly how to calculate the date for all kinds of cases. Okay?
And so I believe since I'm the beneficiary, so I cannot file for. I was reading through the entire USCIS document yesterday, and I figured out since I'm the beneficiary of the petitioner, so I cannot file a notice of appeal or motion. Is that correct?
Okay, so I don't understand that question, Ms. Gupta. Let me try again. Let me try to understand what you just asked me. So your question is, let's say it's my father's case, okay? So my father filed for me, we filed 485, etc. USCIS threw out my case saying you're not protected by CSPA. Can I myself fight that case without my father? Is that what you're asking?
So just some clarity here. My aunt, who is a U.S. citizen, filed for my mom's green card while she was in India. My mom being a single parent, and I qualified as a beneficiary because when the case was filed, it was in 2005.
Right.
And back then I was below 21 years. So I qualified as a beneficiary. Now, when my mom, she appeared in the U.S. consulate in Mumbai last year, I was not denied, but I was told your case cannot be approved because you aged out.
Yeah, that is the denial. Not approved means
and
denied.
now when I...
Yes.
Okay. Okay. But it wasn't put on the passport because I already held the F1 OPT visa. So I flew to United States on my existing visa. I'm still in US, and my mom, she is in US with the green card. Now with the new CSP ruling, I feel that I can file for what is, the new...
Hang on. This requires exact computation. I doubt you have a case, but I told you in that email also, sit with the lawyer and do the math. I can't do the math on the run. Somebody has to sit with you, figure it out. I would be amazed if you qualify, but you never know. Have somebody go over the numbers with you. Okay? This is
Okay.
all a matter of
So
numbers.
can I reach out to you?
You can certainly reach
Can
out
I
to me.
reach out to you for the number calculation?
You can certainly reach out to me. Just send an email to help@immigration.com. I'll see when we can get you in as early as possible next week. Okay?
All right. Thank you very much.
You're welcome. Good luck. This is, let's see. So this is done. Area code 949. We have 3 more people left. The next one is from Connecticut, area code 860. 860, I can hear you. Go ahead, please.
Hi, Rajiv.
Hello.
So my question is on green card. I-140 base, employment base.
Mm-hmm.
So my company has applied. I'm in a PERM step, so PWD approved, and PERM is applied this month. And my H1B max out next year, March. And there are, so before applying PERM, my attorney, they confirmed no layoff this year in the company and everything good. So based on the current timeline, PERM will be approved in next 7 or 8 months. And after that, also I-140 will be approved in the premium process. So that both of these processes can be done in this year as per the current timeline. So my question is, my company is also going under merging. So they are merging with another company, and it's after I-140 approved, if I got a layoff as part of the merge. So is there any option that I have after that?
Yeah.
Because in I-140, we have to stay with the company for 6 months, right?
No, hang on one second. So what happens is, the moment your I-140 is approved, the priority date is yours to keep. They'll let you keep your priority date. You have to start the green card again if you want to change employers, but you will keep the old priority date. So that's one part. The second part is, if you want to extend your H1B beyond 6 years, your I-140 must remain approved for 180 days. You don't have to be with that employer for 180 days.
Okay.
So if nobody,
So
let me finish. So if nobody revokes your I-140 for 180 days, you should be able to keep extending your H1B with any employer. Okay.
Okay, sounds good. So, but in that case, I have to check with my employer and attorney that if that happens, I hope that not happens. But if that happens, I have to check with my employer and attorney that it's gonna be revoked or not. It's up to the employer. Right?
Yeah, it's not required by law.
Yeah.
Revocation of I-140, unlike H1B. H1B you have to revoke. I-140 you don't have to revoke. You can tell them, please don't revoke until after 180 days.
Okay.
Okay. Good luck.
Thanks.
You're welcome. Okay. I know. You see, I'm confused. I don't know if I finished Massachusetts, area code 857. Let me double check this because I have 2 more people only. I thought I just finished Massachusetts. 857, Massachusetts. Did I answer your question or no?
Hi, sir. No, this is a different question.
Okay. Go ahead.
Am I audible?
Yes, you are.
Actually, this is for my friend. All right, thank you. This is for my friend who's on F1 visa and OPT.
Okay, stop. Did you say F? Hang on. Did you say F as in Frank, F1 visa, student visa, OPT?
F1 visa, student visa. That's
Yeah,
right,
okay. All right. So F1 OPT. First year OPT or OPT extension?
It's first year F1.
All right, ma'am. Go ahead.
Yeah. So they interned at Amazon and the offer was deferred. And Amazon also offered an amount,
For the same. But now my friend is working with another organization. So can my friend accept this payment given that my friend can file a WA tax form?
Okay, so let me try to understand this question. Is your friend still on OPT?
Yes. He's on F1 visa. He has a EAD card.
Okay, ma'am, let's try it again. So your friend had 1 year of OPT, correct?
It's the first year.
Yeah.
My friend is on OPT.
Yeah. So he has 1 year of OPT. How many months did he work for Amazon?
That was the CPT and as an intern.
Ah,
And,
so
and number of
so
months was
so
4.
so this is your question. Your question is, he worked for them, let's say 4 months, just as an example. He worked for them 4 months. Then that job was over. Now, after a couple of months, they want to pay him for the time he worked. Can they do so? That's your question?
There's a little change in that. Actually, now they deferred their full-time offer, and they offered to pay some amount because they deferred the offer. And
So-
as an international student, they cannot wait for like 6 months to join Amazon. So they had to take another offer from another company and work there.
Is he still on OPT though?
He is on OPT, yes.
Okay. In my opinion, he can take that money. So what you are saying is, because they could not give him a job right away, assuming it's for H1B, they said, okay, you know what, we'll give you a certain amount for deferral. Okay. So that's not for work done.
That's right.
That's a compensation for something they wanted to do but couldn't do. I don't see why that's a problem taking the money. He can check with the DSO of the school, but if he is still on, if he's on OPT and that money was coming from the CPT time, I don't see any problem in taking the money. Okay?
All right. Thank you, sir.
Good luck, ma'am.
Yeah. Thank you.
You're welcome. The last question is from New Jersey. New Jersey, I can hear you. Go ahead, please.
Hi, sir. I posted question number 3 here, but I joined in the last moment.
Wait for the recording
I
then.
want to get make
wait,
sure that I got.
wait for the recording because I've already answered that question. I won't do it again. Okay? Wait for the recording. Thank you, everyone. I will speak to you all again in 2 weeks. Okay? Please log in on time. Don't waste my time making me repeat answers. I won't do it. Good luck and good talking to all of you. Thank you.